Hello, my name is Jordan, and today my group and I will be examining medical negligence based on the Bolam Test and to what degree is it still applicable in the United Kingdom and Malaysia today. The word tort emerged from the Latin word tortus, which means twisted or wrong, and tort merely implies a wrong that has been perpetrated. In Steele's description, torts are wrongs. To be somewhat more exact, torts are domestic offences in which law will cater a remedy. This remedy will be enforced against one party to the advantage of the other, and it will reflect and maybe rectify the offence committed. Tort law comprises of four essential components, which are an obligation of care enforced by the law, a violation of that obligation by the tortfeasor, the damage endured by the claimant, and the remedies in the form of unliquidated damages. Tort law in the United Kingdom originates from the 14th century. It is a type of common law which began with a verbal custom of tribal justice in Britain and was evolved into a distinct, cohesive national body of regulations and was gradually placed in a writing by judges. It was ultimately imported as the law of British colonies all over the world. The history of tort law is obtained from the form of action approach in which the claimant can only sue on an existing writ within an entrenched form of action. The primary origins of tort law in Malaysia is derived from English case law, regional judicial judgments, and common law assumptions which have been systemized into local statutes. English common law is consistent with Section 3 of the Civil Law Act 1956 in Malaysia. Section 3.1 suggests that the common law of England and the regulations of equity as governed in England on the 7th of April 1956 must be placed in application in West Malaysia or any other part on the condition that it must be authorized by the states of Malaysia and their particular occupants and is accountable to specific provisions under local situations where necessary. There are three classifications of torts, which are intentional torts, negligence torts, and strict liability torts. Negligence is the most common class of tort, which can enforce an obligation on one individual to be careful of injuring another individual or another's possessions. There's a code of conduct in which everyone is required to mirror, and it is the citizen's lawful obligation to behave in a specific manner to decrease the likelihood of endangering others. The failure to obey this principle is recognized as negligence. As opposed to intentional torts, cases of negligence do not include deliberate actions, but instead are when an individual or entity is careless and fails to produce a duty owed to another person. The test for negligence is the reasonable man's test. Examples of negligence torts are car or motorcycle accidents, slip and fall accidents, pedestrian accidents, and medical malpractice. In negligence torts, the liability of the defendant depends on the capacity of the defendant. As Lord Justice McGaw stated in Nettleship and Westland, it is preferable that there should be a reasonably certain and reasonably ascertainable standard of care, even if on occasion that may appear to work hardly against an inexperienced driver. The standard of care required by the law is the standard of the competent and experienced driver. It is not a valid argument against such a principle that it attributes tortious liability to one who may not be morally blameworthy. Many of these cases involving special skill concerns medical negligence. Here, the defendant should be compared with a reasonable person of the same specialism and status. As an illustration, a general practitioner is not judged by the same standards as a consultant cardiologist. One of the problems in this area is that there is often no single right way of proceeding. Faced with a particular patient, one doctor might recommend surgery, but another might recommend treatment with drugs. The courts do not insist that one of these approaches must be right and the other wrong. They require that the defendant has acted in a way that would be supported by a body of a respectable medical opinion.
The initial position with regards to medical negligence can be found in the case of Bolam v. Friern Hospital Management Committee. In 1954, the plaintiff, who was suffering from mental illness, was advised by a consultant attached to the defendant's hospital to undergo a procedure called electroconvulsive therapy. He later consented by signing a form that was not one with the risks involved, among which the risk of fracture. There was evidence, however, that the risk was substantially small, 1 in 10,000. The patient underwent the first treatment without issue. During the second, he sustained fractures. It is worth noting that no relaxing drugs or manual control were used. Male nurses were held a position on each side of the patient during the treatment. The use of relaxing drugs would have mitigated the risk of fracture. However, one of the two groups gave opinion in the case mentioned that relaxing drugs increased the risk of mortality. It is worth noting that the other body preferred the use. Similarly, there are two bodies of opinion on if relaxing drugs were used, manual control should be used. So two different views held among competent professional men on the question of if a patient should be expressly warned for the risk of fracture before being treated, or should be left to ask what the risk actually was. There are evidence of cases of mental illness, the explanation of risk might not even affect the patient's decision of whether to undergo the treatment. Here, subsequently, the plaintiff sued for negligence in administering the treatment. The lack of use of either drugs or manual control, and the fact that he had not been warned of the risks. The Mayor Justice held that he is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art. Putting the other way around, a man is not negligent if he is acting in accordance with such a practice merely because there's a body of opinion who will take a contrary view, and in turn the standard of care towards specific professions was born. In addition, Mayor Justice further explained his reasoning for use of this rule. That does not mean that a medical man can obstinately and pig-headedly carry on the same old technique if it has been proved contrary to what is really substantially the whole informed medical opinion. Further clarified, these rules' intentions was to avoid a repugnant situation where a doctor believed that the acts and ways of the 18th century were most beneficial today. It would be hard to say criticisms of Bolam's test are few and far in between. They seem to be overprotective and differential towards doctors and created a lasting perception that medical profession was above the law. J.L. Montrose in his journal, Is Negligence an Ethical or Sociological Concept?, discussed how experts may blind themselves by expertise. The court should guard the citizen against the risks which professional men and others may ignore. The principles codified in Bolam did not stop after Bolam. The extent to which it should be open to the courts to find professional judgments exercised negligently has been a much disputed question. In Maynard v. West Midlands Regional Health Authority, the House of Lords held that doctors exercise a clinical judgment in a manner thought to be appropriate by a body of professional medical opinion cannot be regarded as simply negligent because the trial judge preferred an alternate body of opinion. Sidways and Board of Governors of Bethlehem Royal Hospital, the House of Lords held that the test applied to not only matters of medical diagnosis and treatment, but also the question of the amount of information that a medical practitioner must give to a patient as to risks involved in the perceived procedure. Lord Scarman, in this case, summarised the results of Bolam Test as, the law imposes a duty of care, but the standard of care is a matter of medical judgment. These decisions, however, received a vast amount of academic criticism, and against this backdrop, the nature and extent of Bolam principle was again considered by the House of Lords in Bothwell v. City and Hackney Health Authority.
The case of Bolito against City and Hackney Health Authority was a clinical negligence case that reached the House of Lords. The Bolito case involved a 2-year-old boy who was admitted to the hospital suffering breathing difficulties. He was not seen by a doctor. Shortly after his second attack of breathing problems, his breathing failed completely, he suffered a heart attack and died. His mother sued the health authority on his behalf, arguing that he should have been seen by a doctor who should have intubated him, and that it was the failure to do this which caused his death. The doctor on duty at the time maintained that even if she had seen the boy, she would not have intubated him, which meant that the court had to decide whether she would have been negligent in not doing so. The doctor was able to produce an expert witness to state that intubation would not have been the correct treatment, and the claimant was able to produce one who said it would. In this situation, the Bolam principle had always been taken as suggesting that the doctor was therefore not negligent. Other medical opinion might disagree with what she did, but she could produce evidence that it was a practice accepted by a responsible body of medical opinion. Lord Brown Wilkinson, delivering the leading judgment with which the others agreed, thought differently. While agreeing that the Bolam test was still the correct one to apply, he said that the court was not obliged to hold that a doctor was not liable for negligence simply because some medical experts has testified that the doctor's actions were in line with accepted practice. The case before House of Lords, he concluded, was not one of those rare situations, and so the claimant's claim was rejected. The legal principle in this case is although the Bolam test still applies, a court is not obliged to find a doctor not liable for negligence purely because other medical experts have testified that his or her actions were correct. In order to determine the legal standard of care, the court has shown a definite movement towards applying the Bolito principle in recent cases. In the case of Penning against East Kent Health Authority, the cervical smears of 4 patients were reported by cytoscreeners as negative for early cancerous changes. But all the 4 patients went on to develop invasive cervical cancer. Reviewing the original slides, there was a division of expert cytopathologists' opinion on what the slides showed. The defendant health authority submitted a defense in Bolam, maintaining that the screeners exercised ordinary skill and judgment. However, the Court of Appeal supported the trial judge finding on the basis of fact that the smears did demonstrate abnormalities and that those abnormalities should have raised suspicion in the mind of any reasonably competent screeners. In reaching his judgment, Lord Wolf referred to the earlier dicta of Lord Justice Bingham, advising caution in the interpretation of some expert evidence. In resolving conflicts of expert evidence, the judge remains the judge. He is not obliged to accept evidence simply because it comes from an illustrious source. He can take account of demonstrated partisanship and lack of objectivity. In a later case of misdiagnosis, the defendant obstetrician was put to proof under the maxim to demonstrate how it was that he missed the intrauterine brain defect of holoprocessively. The trial judge considered precedents set by Bolito and Penny and held that the claimant had failed to establish negligence. However, Bolito has made an impact on medical negligence cases such as Marriott against West Midlands Regional Health Authority. The claimant had suffered a head injury after a fall at home. He then spent the night in the hospital but was discharged the next day after a field test. After continuing to feel ill for a week, he called his GP, who could find nothing wrong but told the claimant's wife to call him again if her husband's condition got any worse. 4 days later, he became partially paralyzed, and this was later discovered to be a result of the original injury. He claimed that the GP had been negligent in not referring him back to the hospital, given that the GP did not have the resources to test for the condition which he was eventually found to have. At trial, his wife, expert witness, claimed that given the symptoms he had shown, the GP should have sent him back to the hospital for more tests. However, the GP brought expert evidence to suggest that although this would have been a reasonable course of action, keeping a patient at home for review was equally reasonable in the circumstances. The old Bolam approach would have required the judge to fine for the GP, given that he could prove that a reasonable body of medical opinion supported his action. However, following Bolito, the trial judge looked at the reasonableness of his opinion given the risk to the claimant and concluded that, in the circumstances, deciding to review his case at home without asking for further tests was not a reasonable use of the GP's discretion. He therefore found the GP negligent.
In conclusion, the test for the standard of care in law expected of doctors is based on the principle enunciated in Bolam. Put at its simplest, the test is that a medical practitioner does not fail to reach the standard of care if a responsible body of similar medical peers support the action in question. However, the judgment in Bolito suggests a judicial move at the highest level to shift the balance from an excessive reliance on medical testimony supporting a defendant doctor to a more inquiring approach to be taken by the court. It may no longer be sufficient for practitioners' actions to be Bolam defensible. The court would seek to determine whether such action is Bolito justifiable. In short, the traditional Bolam test is unlikely to survive in its basic form. Medical practitioners should recognize that the time has come to say bye-bye to Bolam and to take account of the new requirements created by Bolito.
The Malaysian law adopts a common law approach in developing its own law. English precedent is still binding and relevant in Malaysian law, as stated in the Civil Law Act 1956. The Civil Law Act 1956 is an act that was passed to provide the general, specific, and non-application of English law in the Malaysian law. Section 3 sub 1a of the Civil Law Act states that the common law and rules of equity in England are still applicable in West Malaysia before the cut-off date of 7th April 1956. In regards to medical negligence, the Malaysian law follows the precedent of English law, where the Bolam Test is adopted. The Malaysian position on medical negligence is that a doctor is not guilty of negligence, and if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular act, as per Justice McNair in the case of Bolam. In regards to medical negligence, the Malaysian law follows the precedent of English law, where the Bolam Test is adopted. The Malaysian position on medical negligence is that a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular act, as per Justice McNair in the case of Bolam. The case of Chin Kiao and Government of Malaysia and another was one of a few Malaysian cases which applied the Bolam's test. In this case, an old lady was brought to a hospital for treatment of an ulcer on the right ankle and swollen glands to her thigh. After an examination, the doctor on duty administered an injection of procaine penicillin to her, from which the old lady died within the hour. The deceased had an allergic reaction to penicillin, which had been written on her patient card but was disregarded by the doctor. The court applied the Bolam's test, and the doctor failed in his duty to make appropriate inquiries before causing the penicillin injection to be given. Another case that is relevant in this regard is Celaya Anak Lelaki Manukam and another and Kerajaan Malaysia. In this case, a child was referred to a hospital and diagnosed with a perforated appendix. An appendectomy was performed, and during the surgery, the doctor realized that the child had been wrongfully diagnosed. On this realization, the doctors closed up the surgical wound, but the following day, the child died. It was found that the cause of death was due to acute hemorrhagic pancreatitis. The court held that the respondent was not negligent from the wrongful diagnosis, but from the myopic and inflexible approach in the diagnosis, without considering other probable sources that may have caused the child's sickness. This was held to not be a diagnosis at all of an ordinary competent doctor. The Bolam's test was also applied in the case of Kaunan Singh and Nagama and others. The plaintiff in this case suffered minor fractures in an accident and was taken to a nearby hospital, where a complete plaster cast was applied to his leg. The plaintiff, after some time, complained that his plastered leg is getting painful, but the doctor on duty did not do anything for him. Eventually, the doctor noticed that the plaster may be too tight and removed the plaster from his leg. He was transferred to another hospital where an operation improved his condition, but gangrene developed and the plaintiff's leg had to be amputated. The court held that the plaintiff was not given a fair and reasonable standard of care and skill expected of an ordinarily competent medical practitioner. The breach of duty of care consists of a lack of skill in plastering the leg and lack of proper observation in monitoring the patient's response to the treatment after it was given, so that by the time the hospital realized that something was wrong, it was already too late. It is clear that the Malaysian law applies the Bolam's test in determining whether a medical practitioner has breached his standard and duty of care. However, recent developments in the law has shown that although Bolam's test is still valid in this regard, there has been a departure from it in regards to medical practitioners providing advice to patients about the risks associated with the proposed treatments. A new rule was established and favoured by the Malaysian courts over the Bolam's test.
Moving on to departure from Bolam, the court departed from the Bolam's test in regard to medical practitioners providing advice about the inherent risks of the proposed treatment to patients. In cases involving this matter, the Malaysian law will adopt the test from Roger and Whitaker. Rogers and Whitaker is an Australian case which involves a woman who lost sight of her right eye when she was a child. She agreed to an eye surgery after consultation from an ophthalmic surgeon. The surgery was conducted skillfully, but the patient developed sympathetic ophthalmia in her left eye, which when added with the inability to recover sight in her right eye, resulted in her becoming almost completely blind. The High Court of Australia held that medical practitioners do have a legal duty to inform the patient of the risks associated with the proposed treatment, and failure to do so may amount to a breach of duty of care.
Okay.
As per Mason's Chief Justice in this case stated that the law should recognize that a doctor has a duty to warn a patient of a material risk inherent in the proposed treatment. Therefore, the doctor in this case was negligent. This rule is further approved in the case of Nazakis and Western General Hospital, where the rule of Whitaker is extended to cover not just providing advice, but also includes diagnosis and treatment. The Malaysian law has departed from the Bolam's test and adopted the Whitaker test. As was established in the case of Fufiana and Dr. Su Fokmun and another, in this case, the appellant was involved in a car crash and was found to have suffered multiple injuries. The most serious injury was being dislocated vertebra. The respondent prescribed a treatment for the appellant to reduce further dislocation to the vertebra, but it failed. Other operations were conducted, but all of them failed to reduce the dislocation. The respondent conducted further operations to move the vertebra back to its original positions,
and inserted a wire loop to stabilize the spinal cord. This procedure was unsuccessful and the appellant was paralyzed. The respondent appealed to a neurosurgeon who examined the patient and found that the wire loop may be pressuring the spinal cord, leading to paralysis. The respondent performed an operation to move the wire loop, but the appellant remained paralyzed. The case was brought before the federal court, and Siti Norma Yaakob, Lord of Justice, in this case stated that the Bolam Test has no relevance to the duty and standard of care of a medical practitioners in providing advice to a patient on the inherent and material risks of the proposed treatment. Therefore, it is concluded that the Bolam Test is irrelevant in proving negligence when providing advice to patients about the risks of a proposed treatment. This was further affirmed in the case of Hassan bin Datullah and Kerajaan Malaysia. The Court of Appeal in this case overturned the High Court decisions on the grounds that the trial judge misdirected herself by adopting the Bolam Test to determine whether the defendant had breached his duty of care to the appellant. It was held that determination of the standard of care of medical practitioners in a medical negligence should rest with the court. This decision is made in accordance to Fiona, and the Bolam Test was rejected. Based on this, it can be seen that there has been a departure from the Bolam Test in Malaysian law in terms of medical practitioners providing advice to patients regarding potential risks.
In conclusion, the standard and authority of both the UK and Malaysian law on medical negligence is still, to a certain extent, a question for courts. The generally accepted test is still the Bolam Test. However, as formally discussed, this has changed somewhat and is still subject to change. Specific areas of informed consent and the risk involved are still subject to the jurisdiction of Bolam and Fiona for the English and Malaysian law respectively. Based on the judgment from these cases, it can be seen that the court leans towards a patient-based test, as for the cases of Bolam and Fiona, than the Bolam Test, which is far more doctor-based. It is recognized by courts that the determination of negligence of medical practitioners should lie with the courts, not with other similar medical peers. The courts may be able to allow for claims against immoral conduct from medical practitioners, even if that conduct was supported by other medical peers. Therefore, it can be concluded that Bolam Test is still relevant in determining medical negligence both English and Malaysian law, but this is only to a certain extent. It should be noted that Bolam Test may not be expected to survive for long in both English and Malaysian law, as the courts have ruled for departure from it in the past in both jurisdictions.